From the Western District of Texas, a part of the ruling from federal judge David Counts in United States versus Perez-Galan. Before Bruen, the Second Amendment looked like an abandoned cabin in the woods. A knot of vines, weeds, and roots, left unkempt for decades, crawling up the cabin sides as if pulling it under the earth. Firearm regulations are that overgrowth. Starting with the Federal Firearms Act of 1938, laws were passed with little, if any, consideration given to their constitutionality. That is, until the Supreme Court intervened in Bruen. No longer can lower courts account for public policy interest, historical analysis being the only tool. But after going unchecked for almost 100 years, today's tangle of gun laws has left lower courts with a Gordian knot. And after engaging with this nation's traditions of firearm regulations several times already, the court's unanswered question is whether Bruen demands lower courts manicure the Second Amendment's landscape by scalpel or chainsaw. Quoting Thomas from Bruen, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command.